Major breaking news out of the state of New Jersey. The vast majority of New Jersey's new gun control law dealing with carrying guns has been declared unconstitutional for the purposes of a preliminary injunction by Judge Renee Bumb. Very big news. We're going to break it down in a short video right here, right now, and then we got a much more extensive video coming thereafter. But for now, we're just going to summarize it. Big news and great news. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Box of Don, a proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and yes, author of the brand new book, best-selling book indeed, Disarmed: What the Ukraine War Teaches Americans About the Right to Bear Arms. Check it out. A lot of lessons for Americans in that book. We always want to learn from the mistakes of others, and the Ukrainian people have certainly made a lot of mistakes that we can learn from here in America, so why we never want to give up our right to bear arms. Okay, breaking news. We know that there is a major legal challenge. Two challenges consolidated together in front of Judge Renee Bumb, federal district court judge in New Jersey. One case is called Coons, one case is called Siegel. The Coons lawyers are, the Coons case involved a legal challenge to the new concealed carry laws brought by the Firearms Policy Coalition and the Second Amendment Foundation with the lawyer David Jensen. And then there is the lawsuit in the Siegel case brought by the Association of New Jersey Rifle and Pistol Association, run by Scott Bach with an attorney, Dan Schmutter. Congratulations to you guys. They got a big win today, a 240-page opinion by Judge Bumb. There was a 4-page order that explains what she declared unconstitutional for the purpose of preliminary injunction, and 240 pages explaining why she did that. Now, here's what we're going to do. I'm going to do the summary video of about 10 minutes or so, giving you the highlights of this decision. And then I'm going to do a much more extensive video that's probably going to be like an hour long to break it down in a much more geeky way. I want to get this out to you first and foremost, though, this summary. The big thing is this. Judge Bumb looked at licensing rules, specifically how you get the license to carry. And then she also looked at the quote-unquote sensitive places rules, which are euphemisms for gun-free zones. She also talked about the proper way to apply the Supreme Court's decision in Nysurpa versus Bruin involving the Second Amendment. So I'm going to hit the highlights here. First of all, what Judge Bumb said is she was mostly unimpressed with the quality of New Jersey's arguments. Specifically what Judge Bumb said, and again, I'm going to put a link to the opinion down below. Judge Bumb starts out by pointing out that most of New Jersey's gun control laws are focused on harassing law-abiding gun owners and not the criminal class. She even goes so far as to quote the famous Cesare Beccaria. As you know, I'm the one that's been pushing Cesare Beccaria, the Italian Enlightenment philosopher from the 18th century that was very influential on the founding fathers, including Thomas Jefferson and John Adams. I'll put a link to my Pepperdine Law Review article here, but she quotes the Cesare Beccaria in part because Beccaria is the one that before we had the Second Amendment pointed out that gun control laws only help criminals. They do not impact the law-abiding except to make them more likely to die in homicides because criminals don't care about gun control laws or armed control laws, and therefore they're no good. She specifically, Judge Bumb cites on page 5 and quotes Cesare Beccaria's view that, again, when you outlaw guns, only the outlaws will have guns, and does a nice job succinctly laying that out. And this is what she says about Beccaria's view, quote, "Those words rang true then, they ring true today. Clearly, the state of New Jersey disagrees with the Bruin decision, but it cannot disobey the Supreme Court by declaring most of New Jersey off limits by law-abiding citizens who have the constitutional right to armed self-defense." Close quote. That is Judge Bumb starting out really hard and favorable to the Second Amendment. Then she goes on to basically say that New Jersey failed to meet its burden of justifying these gun control laws. She points out that this is what she basically says. She says, quote, "The New Jersey legislative record reveals the legislature paid little to no mind to Bruin and the law-abiding New Jerseyans' right to bear arms for public and self-defense. Again, the law's primary sponsor declared that because of Bruin, more New Jerseyans will die as a result of the gun violence period," close quote. She then goes on to say that she, as an inferior court, has to follow the teachings and rulings of the United States Supreme Court, and says that it's clear that the state of New Jersey had no intention of doing so, and that's why she's going to enjoin, which means stop, most of these laws on a preliminary basis. She then goes on to write specifically, quote, this is what's interesting, she says, quote, "Despite numerous opportunities afforded by this court to hold evidentiary hearings involving the presentation of evidence, the state of New Jersey called no witnesses, and despite assurances by the state of New Jersey that it would present sufficient historical evidence as required by Bruin to support each aspect of the new legislation, the state failed to do so, period, close quote. These are the opening lines of Judge Bumb in this long 240-page decision. And then, of course, she goes on and makes the same observation about as you recall, there were some legislators that intervened. I'm sure they got some good press releases out of it, but it's not gone well for them because on page 4, Judge Bumb says essentially that rather than presenting the compelling historical evidence they promised, the state and the legislature interveners have spent their resources writing a narrative that says, absent the court's indiscriminate approval of the new legislation, people will die from quote-unquote gun violence. And she specifically says, and this is very important because she points out the legislation is not about criminals, it's about punishing law-abiding Americans who want to exercise Second Amendment rights. This is what she says, quote, "The state of New Jersey and the legislature interveners ignore, and what their empirical evidence fails to address, is that this legislation," meaning what she's about to strike down or large parts of it, "is aimed primarily not at those who unlawfully possess firearms, but at law-abiding responsible citizens who satisfy detailed background and training requirements and whom the state seeks to prevent from carrying a firearm in public for self-defense," period, close quote. So the bottom line is she is saying that this is all about harassing the Second Amendment supporters, has nothing to do with criminals, and she's not going to tolerate it. Then she goes on and talks about what she's going to enjoin, meaning what she's going to declare as unconstitutional. As a reminder, this was a preliminary injunction. A preliminary injunction means the state is not going to be permitted to enforce these various laws, which the order I'll link to down below lays out in detail. You can check it out if you need to. But basically, the state cannot enforce these various laws during the duration of this lawsuit. A preliminary injunction is in effect from the day it's entered until the end of the case, and then she'll decide whether or not to enter a final permanent injunction. Only time will tell. But so far, it looks pretty good for most of these issues for the Second Amendment community. Specifically, this is what she says. She is declaring to be unconstitutional and likely to violate the Second Amendment and may not be enforced until the end of this case, the following laws. The quote-unquote sensitive places rules that ban you from carrying guns in the following places. That would be libraries and museums, bars and restaurants that serve alcohol, entertainment facilities, casinos, film sets, private property that is open to the public, and anything that prohibits the use of the carrying of functional firearms in motor vehicles. She also enjoined the in-person interview requirement of the concealed carry permit applicant's character endorsers, meaning if your neighbor says that you're a good applicant for a concealed carry permit, she struck down the rule that says that the police get to interview your neighbor. They get to interview you as the applicant, but not people that support your application. That is what she said. I'll put a link to this down below. Bottom line is, if you look at how she did this on the licensing rules, and again, we're going to get into a lot more detail. It's going to be like over an hour-long video. It's the next thing that's coming out on this decision, because this is 240 pages. The table of contents alone is 3 pages single-spaced. That's the table of contents alone. And there's hundreds and hundreds of citations here, but I want to get this out to you really quick. Right now, the good news. So here's the bottom line. She said that when it comes to the licensing rules that were being challenged, it is true that under the Second Amendment, it is fine to deny people who are dangerous to society, in a violent nature from being able to possess firearms. She said that makes sense under the Second Amendment, but what she says is not acceptable is the view of the anti-gun movement in the state of New Jersey that's simply showing that someone is not virtuous, meaning they don't respect like recycling laws. That is not enough to take away their right to keep and bear arms. And she said the reality is of these permitting regimes, all the purpose of that is to make sure that people are not dangerous. She, by the way, raised the question as to whether or not shall issue permitting regimes are constitutional. Specifically, she says, although the Supreme Court indicates they're generally constitutional, as applied, they may not be constitutional. So she has opened up the door to possibly listening to arguments during the duration of this case about whether or not the way these shall issue permitting regimes are applied, whether or not they're constitutional. She's going to take more discovery on that, and that will be litigated going forward. But she did cite some interesting points about that. We'll see where that goes as this case progresses. Then the other thing she goes on to say, and this is a very big deal, she knocks out the insurance mandate. Specifically, there was a law that says that to carry you had to get insurance. She declared that as unconstitutional on a preliminary basis on the grounds that there's nothing there in the historical foundation of America to justify that. She then draws a distinction from the so-called surety laws that we've talked to before. These surety laws, as you recall, in the late, in sort of the mid early mid-19th century, after the founding era, says that if you carry a gun and someone thinks you're a danger and they take you to court and you're found to be a danger, then you may have to post a surety. This is a big argument that the anti-gunners like to make, to say this justifies all sorts of carriage restrictions. She rejected that entirely. She says this actually proves the point of the Second Amendment because it shows that everyone has the right to carry a gun. And even back at the time of early part of America, if you were found to be a danger to yourself or to someone else, the only thing that occurred there, at least under the surety laws, was that you had to post a bond you can continue to carry. So she did not find those as persuasive historical evidence as to why you could justify someone to carry a gun with insurance and require them to have insurance to carry a gun. She then went on to say that at the time of the founding there was no insurance requirement for carrying a gun, and therefore it's not allowed under the Second Amendment. Then she turns her attention like a laser focus to these quote-unquote sensitive places, which again is a euphemism for government-mandated gun-free zones, and she knocks out quite a few of these. Specifically, she starts, and this is the big one. This is the big one. Two big ones. I want to hit the two big ones first, and then we'll run through the little ones fast. The big ones are this. Number one, as she says, that the state of New Jersey's argument, this is that every single place that the state of New Jersey owns, if it's state property, including highways, they get to ban you from having a gun on those. No different than if I deny you from the ability to come into my home, right? I say, don't come into my home with guns. I don't allow guns in my home. Well, that's one thing. And the government was trying to say in New Jersey that because New Jersey owns all this property, they, as the proprietor, as the owner of this property, can just say, we don't want guns on our property. She rejected that outright. That said, that's absurd. The Second Amendment applies to them, and they cannot do that. So that's a very big deal. She rejected this notion of the state as proprietor as a basis for allowing, for banning guns everywhere that the state owns. Then, this is the other huge argument that we won. This is the default property rights rule. Just to jog your memory why this is so dangerous to us. Basically, a few years ago, some academics came up with this theory that says all we need to do is pass laws in states to say no one is allowed to carry a gun in a place that's open to the public unless they get specific permission from the owner of the convenience store, of the deli, and whatnot. And if those persons don't give specific permission, then you can't bring a gun on there. And if you do, you get to go to jail for years, which in New Jersey, I think is 3 to 5 years if you go into a convenience store that doesn't allow guns and you have a gun, even if you're doing so peaceably. The good news that Judge Bumb specifically rejected this. She rejected all the laws associated with this, and what she said was this. She said she's not going to touch issues associated with the default position in terms of private property that's not open to the public, because that wasn't really being litigated. No one was litigating here the default rule about you can't bring a gun into someone's home without permission. This was not about that. This was all about people bringing guns into places that were open to the public. Convenience stores, pharmacies, grocery stores, law firm offices, whatever. That was the idea. New Jersey passed a law that says you can't go into these places without first getting permission to carry a gun, which effectively would make it impossible to carry a gun because you don't even know who to get permission from when you pull over on the highway to go into some, gas station. So she said, no, that default position, there's no basis in American law for that. She rejected that. And what's also interesting here, and this is very important, there was a historian professor from Princeton that the New Jersey brought out to try to justify this, and this is very important. Judge Bumb said that the views of a historian are based in theory, and under the Supreme Court precedent in the Second Amendment, it's not her job to figure out the historical theories of some professor. No, she says her job is to look for primary sources, actual laws that were on the book at the time of the founding, and if those laws are not there, then she's not bound by it. And this is very important because I've talked a lot about the importance of following actual primary source historical gun laws. That is what the government has to come forward with. They can't just come forward with some, historians from anti-gun Ivy League universities to espouse some musings about the meaning of the law. No, they can't rewrite the Second Amendment with using academics from these schools. They have to actually come forth with actual laws, and Judge Bumb completely agreed with my view in this decision, and that was great news. Now, on some of the other specific places, just to do a quick rundown, she says that there was no evidence or no suggestion from the government that you couldn't bring guns onto property in places like zoos. I'm going to post down below a description of 2 documents. There's going to be a 4-page order that specifically lays out her order, and then the 240-page opinion that describes the order. Now, if you look at the order, you will see these are the specific places that, as I read this, she is enjoining, meaning that the state's ban on bringing guns into these places is not constitutional under the Second Amendment because the state did not meet its burden. So here's the one again, just to go through the specifics. Libraries and museums, the state did not meet its burden. Bars and restaurants that serve alcohol, and she points out, by the way, this would apply to people who aren't even drinking. And again, she said there was no historical foundation for that, so therefore she enjoined it. Entertainment facilities, no historical foundation for that. Then she also says that the state law cannot just automatically ban casinos from having guns. Again, nothing prevents the casinos as owners of the property from banning guns, but the state cannot do it for them. Then she goes on to say that you cannot ban guns in cars because, again, people need guns more likely in cars than even at home. And she even cites statistics about the high number of carjackings in the state of New Jersey, which I thought was quite interesting. So again, the next video is going to be a lot more extensive than this, but this is the summary. Overall, this is very good news. She struck down the bulk of these new carry laws. She left some things up, but the good news is I think the things that she left up, some of them were because she felt the plaintiffs lacked standing, which could probably be fixed with new plaintiffs or more allegations from the current plaintiffs. She also said that in some instances, like security involving airports, she needed more facts and discovery. That presumably will be coming in the next 6 months as the lawyers litigate these issues. And then she also makes observations that she's willing to reconsider some of her prior findings in the duration of this case. And I think really the conclusions in support of the Second Amendment are going to stand up to scrutiny, even in the Third Circuit Court of Appeals. And I think some of the areas where she didn't rule in our favor, I think there's still a window where we can win those arguments with a little bit more work and a little bit more discovery and a little bit more support. I think that is winnable, but overall, this is an extremely good day for the Second Amendment in the state of New Jersey. Take a look at this, and for those of you living in New Jersey, make sure you check with your attorneys to make sure you comply with all the laws, of course, because there's a lot of moving parts here, and I can only summarize it generally here on YouTube. But overall, very good day for the Second Amendment. Judge Renee Marie Bumb did a wonderful job on this, and I think there's going to be more to come, by the way. Okay, folks, if you haven't subscribed to the Four Boxes Diner, please do so. We'll see you again soon at the Four Boxes Diner.
Orders up. Table 2A.